Hello everyone, welcome to this channel. We have now reached to Article 26, titled Freedom to Manage Religious Affairs, subject to public order, morality, and health. Every religious denomination or any section thereof shall have the right A. To establish and maintain institutions for religious and charitable purposes. B. To manage its own affairs in matters of religion. C. To own and acquire movable and immovable property. D. To administer such property in accordance with law. Article 25. Oh, shit. No. I think the numbering is wrong here a bit. So we have reached to Article 26. I mistakenly said Article 26. Exclude me from that. So Article 25 should be read along with Article 26. While Article 25 guarantees right to freedom of religion to an individual, Article 26 guarantees such right to an organized body of individuals like the religious denomination or any section thereof, and also certain other rights to manage its own affairs. And such rights to manage the affairs of any religious denomination are restricted to matters of religion only. The state cannot interfere in the exercise of such right unless it runs counter to public order, health, or morality. The rights enshrined under Article 26 are, however, subjected to the regulatory power of the state under Clause 2b of Article 25. This means that secular activities connected with religious institutions can be regulated by the state under the law. Thus, Article 26 and Article 25, Clause 2, Subclause B has to be harmoniously construed. Religious denomination in SP Mittal versus Union of India, year 1983, it has been held that a religious denomination must satisfy three conditions. First, it must be a collection of individuals who have a system of belief which they regard as conducive to their spiritual well being. Second, it must have a common organization. And third, it must be designated by a distinctive name. It was further held by the Supreme Court that Aurobindo Society is not a religious denomination because the teachings of Sri Aurobindo only reflect his philosophy and not a separate religion. In Hindu religion, the followers of Ramanuja, known as Vaishnavas, followers of Madhvacharya, Ramakrishna Math, constitute religious denomination. Among Mohammedans, Hanafi, Shia, Sunni, Chishti sects are separate denominations. About regulatory power of state in Raja Bir Kishore Devi versus the state of Orissa, 1964, the Supreme Court held that government may exercise its power to administer the temple or audit its assets, but what it cannot do is to exercise a right to sell or give a lease to others and cannot use temple assets for the welfare of people of other faith. Article 26 of the Constitution gives the right to religious denominations to manage matters of religion, and Article 25 allows the state to make any laws to regulate them. And Sri Adi Vishweshwara of Vishwanath Temple, Varanasi, versus state of and others was the state of UP. 1997, the Supreme Court drew a distinction between religious and secular functions of the temple. The Supreme Court upheld the validity of UP Sri Kashi Vishwanath Temple Act 1983 and held that the act was only pertaining to the secular functions of the administration and management of the temple, and these were not essential or intrinsic elements to the practice of the religion, and the legislature was thus competent to enact a law that did not entrust the government with power to interfere with day-to-day religious practices.